Okay, hi guys! Welcome to this presentation on the law of the sea. This is the second in a series of videos that accompanies Professor David Koplow's class on the Introduction to International Law at Georgetown University Law Center. My name is Natasha Sarna. I'm going to be guiding you through the video. It should last approximately 45 minutes. I know I speak really quickly. I'm going to make an effort. There's a function on YouTube and you can change it to like 0.75 speed. I would encourage you to if it's too fast, but I'm going to try. And something else I'm going to try as well sort of for this video that's new is if I can't get in actual markers on the bar in YouTube, I'll put in manual timestamps. So I'm going to break this down into chapters or at least topics for the zones, the background, special issues. And since this is a pedagogical tool for you, what I would encourage you guys to do is just pause, rewatch, skip to certain sections, really just use this in a way that best supports your learning, however that shakes out. The focus of the video is the 1982 UN Convention on the Law of the Sea, and we're going to focus particularly on parts 2 through 7. I will put relevant portions of the text on screen as they kind of fit, but if you're somebody that learns best with text, it might be useful to just have a copy of that on hand. And the main purpose is really just to familiarize you with one of the key aspects of the treaty, which is the series of maritime zones that radiate out from the shoreline and within which the rights and responsibilities of coastal versus seafaring states are kind of variously balanced. This regime of the zones is one of the most important and interesting developments or innovations really of the treaty. It also accounts for like a really good deal of the text. And understanding the zones is central to appreciating the success and also the continued challenges of the international law of the sea as a kind of doctrine altogether. There are also obviously other important aspects or elements of the treaty that are somewhat beyond the scope of this video, but they will be elaborated in assigned readings and in class, and please feel free to bring any questions you might have to our next meeting. Okay, before we get into the zones, some kind of notes about the background and bigger picture. The Law of the Sea Convention is one of the world's most important and successful multilateral treaties, full stop. It regulates a huge range of human behaviors in, over, under the seas. It applies around the entire planet, and it brings like a degree of order to what would otherwise be, really dangerous, protracted, and costly controversies about resources, access, and jurisdiction in the sea. The Law of the Sea Convention incorporates totally state-of-the-art provisions about environmental protection, which we'll discuss in greater detail later, dispute resolution, institution building, and that's the reason why this course, like actually many others in international law, will really try to use it as a kind of capstone illustration for what we've discussed over the course of the entire semester. So, in short, it's just a really good case study of treaty making, customary international law, resource allocation, conservation, and problem solving. And it pulls together many of the lessons from the last few months. As we've covered in class, the 1982 UN Convention on the Law of the Sea has been joined by almost all states in the world, except, you guessed it, the United States. The treaty has, though, been endorsed by the US Navy, the fishing industry, the petroleum industry, the shipping industry, the environmental community, and a number of others like several presidents, the Senate Foreign Relations Committee. But as of the time of the recording, so it's 2023, just turning into 24, it still hasn't won a 2/3 vote of advice and consent by the Senate. So as you will know by this point, that means that the US hasn't ratified the convention, and so it's not a party to it. However, the US has accepted a lot of the treaty as binding customary international law, and that includes most of all the provisions that we're going to discuss throughout the rest of the video. One of the key differences, and we'll kind of bring this up again as well, is that the US has not accepted the provisions that are in Part 11 that relate to deep seabed mining. But the US is really diligent in kind of both adhering to and very vigorous in enforcing treaty and customary zone rules. So will often protest diplomatically, sometimes physically, when other states make excessive maritime claims. Okay, now we are turning to the 6 zones, and as you may have guessed from their frequent reference already, these provide the structure both for the treaty and for this presentation. In order, in to out, they go internal waters, territorial sea, contiguous zone, exclusive economic zone, which I'll also refer to as the EEZ, continental shelf, and the high seas. For the purposes of the presentation of the treaty, like I said, the ocean is kind of just divided into this series of 6 concentric zones, and they radiate out from the shoreline. They all have different widths and characteristics that we'll discuss in more detail, and they allocate power to seafaring and coastal states. There are also many different kinds of maps and charts that represent these zones. I will put some up around my head right now so you can see them. But same as the video overall, really just focus on whatever depiction makes the most sense to you, because they're all just kind of elaborating on the text of the treaty itself. The fundamental concept that's really guiding these zones in the Law of the Sea Convention is this wish to balance the rights of coastal and seafaring states. This is kind of overbroad, but just to think about it generally, as you get closer to the shore, coastal states will have more power, and as you get farther away, seafaring states will have more rights. Again, just really more importantly, the Law of the Sea Convention was good in that it provided predictability and equity through a comprehensive and specific legal regime to what was beforehand this array of really kind of chaotic competing state practices and claims about the high seas. Another note quickly before we get into detail is that when this treaty and the video refer to a mile, we're talking about a nautical mile. So that's actually 1.15 statute or land miles, which is just over 6,000 feet. Or if you're anywhere else in the world, 1.85 kilometers. Also note, in general, and we've kind of mentioned this, but the rules of the treaty actually don't only apply to the water. They also apply to the airspace above and to the soil below. In this video, we're going to talk mostly about the application of the treaty rules to the water, but just remember that the legal regime applies kind of further than that in a cross-section. Okay, first important thing to talk about is the baseline. This is the starting point. This is the line from which all zones are measured, and everything to the landward side is internal waters. Everything out is territorial sea or one of the other sections that goes beyond that. Under Article 5, the normal baseline follows the mean low water mark, and this traces all of the indentations and sinuosities of a shoreline. And this is an appropriate foundation because normally if you look at any map, the low water mark is going to be sort of very clearly stated for navigation purposes. So it makes that really hard to either manipulate or fake. But not all shorelines are normal, obviously, so the treaty has to accommodate several different kinds of irregularities. For example, if a river flows directly into the sea, a straight baseline is drawn just right across the mouth. Where the mouth forms an unstable delta, the baseline can connect the farthest seaward points of the land. When there's a fringe of small islands in the immediate vicinity of the shore, the baseline can connect the outer points of that fringe inland to the shore. But a baseline along a shore does not reach farther out to any isolated, uninhabited low tide elevation, unless there's some kind of lighthouse or other structure there permanently above sea level. If there's a larger island that's much further offshore, it gets its own baseline that's not connected to the shore. And this can be really, actually very advantageous to the coastal state in pushing its control farther out. To count as an island, though, by the way, the land has to be natural. So an artificial island, and there are some, doesn't get its own territorial sea or EEZ. With respect to the issue of bays, for example, or coastal indentations, Article 10 contemplates 3 different scenarios. The first is a smallmouth bay, second is a largemouth bay, and the third is a historic bay. For a smallmouth bay, a coastal state can draw a baseline up to 24 miles along the mouth of the bay, if it encloses more water than the area of a semicircle that would be drawn there. This is advantageous for the coastal state because it establishes the entire internal bay there as internal waters. If for a largemouth bay, in contrast, the baseline has to go around the interior of the bay, so it's not internal waters. A historic bay, the third category, might not meet the geographic criteria for a smallmouth bay, but because of internationally recognized historic patterns of use, it gets treated as if it were a smallmouth bay, again, which isn't the advantage of the coastal state due to sort of long, continuous, and notorious occupation. So already, like, this tiny subset of provisions necessarily incorporates judgment and flexibility, which requires discretion, negotiation, and adaptation from the affected states. There's a lot of controversies about how to interpret ambiguous and incompletely defined provisions. So for those reasons too, decision makers have to take into account historical practices, economic interests in terms of equity, and also in some cases for this, unique physical circumstances. In prior years, pre-Law of the Sea Convention, it was really important where you put the baseline. It was also a subject of great dispute. So imagine a coastal state could exploit some kind of wrinkle to push their baseline out an extra half a mile. When the coastal state could only claim, 3 miles of territorial sea, which was the case, 3 to 4 miles maybe pre-Law of the Sea Convention, that wrinkle is really important because having control over an area of 3 versus 3.5 miles makes a really big difference. But in contrast, under the convention today, coastal states can usually exercise really considerable control up to 200 miles from the baseline. So a wrinkle that makes it into 200 miles plus 1/2 is comparatively kind of less critical. but extensions of the baseline do matter, and countries will still pay really close attention to how they construct it. Baseline rules are also really important in cases where countries are close together, or when they're sort of situated across a relatively narrow waterway. So, in that case, the country probably isn't going to be able to expand their control the full 200 miles. And we're going to discuss that scenario later at the end of the video within the special topics. But in general, the steam has kind of gone out of debate for proper construction of baseline because the treaty regime allows control so expansively and jurisdiction kind of out into the water. Okay. Now, within each zone, there's also 3 aspects of competing national right that we're going to consider. And we'll look at them for each of the zones: access, resources, and jurisdiction. Sometimes, often actually in class, people will refer to states as having sovereignty in various areas, but that's not really precise enough. So what we want to do is kind of identify specific rights that are established by treaty and customary international law regarding each of the 3 key issues: access, resource, and jurisdiction. And the general question for, that kind of element of the treaty and for this video is who is allowed to do what and where. Okay. Starting with the first zone, internal waters. This is the area, as you might have guessed from the name, that is inside or to the landward side of the baseline. Internal waters, though, are physically connected to the ocean, but they're considered entirely assimilated in coastal states for social, commercial, historical, and legal purposes. So examples in the US would be the Mississippi River, Lake Michigan, and the Port of New York, for example. Within internal waters, coastal states essentially have the same sovereignty that they do over land. Let's break that down, like we said. So first, access. Coastal states, full access to their internal waters. They also, crucially, have the right to exclude others from their internal waters. So a coastal state can prohibit a foreign ship altogether. They can prohibit foreign ships just from a certain country. They can also prohibit foreign ships just of a certain type. Foreign ships have no inherent right under international law to enter another coastal state's internal waters. The normal practice to kind of figure this out is for states to negotiate like bilateral treaties that afford reciprocal port entry rights. Again, though, this can set conditions on the number and types of ships that are allowed to enter. A lot of times in support of commerce, the negotiated rights will be very expansive, but not always. Sometimes, for example, the practice would just be to be relatively permissive for merchant ships entering internal waters, but to require advance notification from warships, which they're allowed to ask for in internal waters. Often, also, coastal states will charge fees to visiting foreign non-governmental ships, and they may require, special procedures for safe navigation, for example. There is a modest exception to this complete control over the access to internal waters, which is that customary international law generally requires that a coastal state offer temporary safe haven to any vessel that's driven there because of distress. So if it's there because it was driven by a storm or some kind of equipment malfunction, they have to be allowed access. And here, the principle of necessity is kind of providing some historical regard for seafarers in trouble in this very sort of romantic image. Okay, so that's access. Resources. Might have also maybe guessed this, but coastal states have exclusive rights to control development and exploitation of living and non-living resources in their internal waters. Nobody else has any right to fish or mine there unless they've been granted explicit permission. And the same goes for jurisdiction. Coastal states can apply their law fully in internal waters. This also includes, by the way, governing activities on board of foreign ships that are temporarily there, except for foreign warships that have sovereign immunity. And as we've seen in other classes, this principle of territoriality is so strong that it means that a coastal state will have both jurisdiction to prescribe and jurisdiction to enforce the rules regarding foreigners and their ships in its territory, including in internal waters. Ordinarily, the flag state on the vessel also has jurisdiction to prescribe and to enforce regarding activities on board the ship, so that's an area of potentially overlapping and conflicting jurisdiction. The usual practice for merchant vessels is for the coastal state to just defer to the flag state regarding activities that are conducted on board the vessel, unless the activity is so conspicuous that it's like disturbing the peace of the port, right? So it's impacting the coastal state. For naval vessels, the usual rule is that the coastal state is not going to prosecute criminal offenses committed on board the vessel. That is the prerogative of the flag state. Okay, next we have the territorial sea if you move out from internal waters over the baseline. Historically, like we just said, this is kind of 3-4 miles long. It's not very big. Nautical miles, so they're slightly longer, but not huge. But under the convention, coastal states are now authorized to claim a territorial sea that is up to 12 miles out from the baseline. So we're going to go and look at access, resource, and jurisdiction for this new 12-mile stretch along the shore. With respect to access, the right of foreign seafaring states to be present in another state's territorial waters is really different from the rules that apply to internal waters, where foreign ships have no right to enter without permission. In a territorial sea, foreign ships have what is called the right of innocent passage. Innocent passage means that there's a right for any ship, including warships, to navigate through somebody else's territorial sea continuously and expeditiously without advance notification, permission, and changes, basically for any purpose. Also, it doesn't really need to be innocent as long as it follows the basic coastal state traffic safety rules. In the exercise of innocent passage, a foreign ship, including foreign military vessels, they can freely enter a coastal state's territorial sea and navigate extensively inside that 12-mile mark. Article 19 of the treaty says that innocent passage must not be prejudicial to the peace, good order, or security of the coastal state. So, good illustration of that. The transiting ship that's conducting innocent passage can't threaten force, they can't do target practice or spy or send propaganda, they can't pollute the territorial sea. Also, submarines have to travel on the surface, and aircraft carriers can't launch or recover aircraft. Again, also, the transit has to be expeditious, so ordinarily the ship can't just drop anchor and hang out there for a while if they're really conducting innocent passage. But so long as the passage meets the treaty definition for innocent, the seafaring state can exercise this right for any reason. They can do simple passage. They can also just do it to annoy the coastal state. They can do it to see maybe how quickly the coastal state responds, how vigorously they respond to somebody else being in their water. And states sometimes do actually undertake these provocations. It's kind of exciting sometimes for the public when the media reports that there is a ship from hostile country X that is 5 miles away from the coast of country Y that doesn't want them to be there. But it's actually totally legal for them to do that. It's just arguably a little bit obnoxious. More about access. Okay, the coastal state can also regulate innocent passage through its territorial sea for some other reasons, like traffic safety, pollution control, protection of fisheries, and customs, which is related to the limitations we've already discussed. Also, the coastal state can temporarily suspend innocent passage in part of its territorial sea for what are called essential security reasons, but it can't discriminate against ships of a particular state when it's doing this. It just suspends all innocent passage. And this right of innocent passage is really, really important to the U.S. Navy. And preserving that right was a kind of key goal during the 1982 treaty negotiations. The U.S. really carefully monitors other states' interference with innocent passage rights, and it protests those violations very vigorously, and we'll kind of turn to that later again. On the other hand, the regime of innocent passage does give seafaring states a lot less freedom than applies to high seas navigation rights, which we'll discuss with the high seas. Resource for territorial sea. Coastal states get exclusive rights to exploit all natural resources in the territorial sea, living and non-living, same level as internal waters. Jurisdictionally, the coastal state's right to exercise jurisdiction is a bit attenuated compared to the internal waters. In criminal cases, for example, coastal states should not arrest a person on board a ship that's engaging in innocent passage unless the ship is in the territorial sea immediately after leaving internal waters, or the crime affects the coastal state somehow. And we should note, so this is from Article 27. Article 27 is a really rare instance where the law of the sea convention uses the verb should instead of the mandatory shall, which kind of highlights the extent of the discretion that's at play here. And for civil cases, a coastal ship shouldn't stop or divert a ship to either attach assets or to serve process on a person or on the ship unless the action arose from that particular voyage. So if it's just going through again, you shouldn't stop it for any of those reasons. Okay. We're already on the next zone. We're moving very quickly at pace, which is great. Next, we come to the contiguous zone. This is a little bit less important and less interesting, but it's good because it provides kind of a buffer between the more highly controlled areas by the coastal state and the high seas. The features are that this extends 12 miles beyond the territorial sea, so it's 24 miles total from the baseline if we're keeping track. And it overlaps the start of the EEZ, which is important. We're going to discuss the EEZ next. A lot of states, for reasons that will become clear, don't really bother to claim a contiguous zone, and if they do claim it out to the permitted 24 miles, but then they rarely will exercise the rights that are available there. There's no special rules for access or resources. It's just treated like the EEZ. But the difference comes in the jurisdiction. So there's some differences there, some higher rights for states than you get in the EEZ for the contiguous zone, this little band that kind of abuts the territorial sea. So a coastal state can act in the contiguous zone to protect itself in 4 key areas: customs, fiscal protections, immigration, and sanitary protections. And the coastal state can arrest and punish violations that occur within land territory, internal waters, or territorial sea. But with the contiguous zone, the coastal state kind of gets to extend its law enforcement just a little bit farther out. And this is primarily useful in dealing with smugglers, polluters, and kind of most, excitingly, drug dealers sometimes too. There are issues though. So how far can the coastal state actually go after smugglers physically? If the parent ship is 25 miles out to sea, so they're beyond the territorial sea and the contiguous zone, and there's smaller runner boats that are kind of offloading it or servicing it, coastal states can definitely go out and arrest the runner craft. But if the runner craft flees outside the contiguous zone, coastal states can also chase it while they're in hot pursuit, so they can kind of keep going after it. If the chase started inside the contiguous zone or the territorial sea, and it was continuous, and it never got into another state's territorial sea, so it's kind of hard when you're along a border. But there are the questions, like, can the coastal state go after a parent ship if it never enters the contiguous zone, kind of if it's being serviced by these smaller ships? Article 111.1 of the convention allows pursuit when, quote, the ship or one of its boats is inside of the contiguous zone. But what do we mean, by one of its boats? Does its boats cover only like little dinghies that are carried on the ship? Does it cover shore-based ships that service it? What if the parent ship is 100 miles offshore or 500 miles offshore? And these are really important questions that the treaty and the state practice have not yet fully resolved. Okay, this is a big section coming up, a big zone. This is the EEZ. We've already mentioned it a few times. I promise this will come up whenever you're talking about the law of the sea and the rest of your careers. It's a pretty important section. It's one of the most important and also one of the most innovative parts of the Law of the Sea Convention. It starts at the edge of the territorial sea, so it incorporates the contiguous zone, and it extends a full 200 miles from the baseline. So it gets cut off at that, 12-mile point, but it extends the remainder, so that it's a full 200 miles from the baseline. Most states, for reasons that will become obvious in a second, exert the maximum possible EEZ. And it's just a really remarkable compromise. It's very generous to coastal states regarding control over resources. That's kind of its primary benefit to coastal states. But it's also very protective of seafaring states, rights of navigation and access on the high sea. So, three sections: access, resources, jurisdiction. Access. In the EEZ, ships of all states have high seas freedom. So, what does that mean? It means they can travel anywhere for any purpose and undertake basically all activities, so they're not constrained to innocent passage. In the EEZ, ships can also freely engage in military activities like naval maneuvers, target practice, launching and recovering aircraft, collecting intelligence. Submarines can operate submerged, which they can't in the internal waters or the territorial sea. Aircraft can fly freely. Ships can undertake espionage. They can broadcast propaganda. They can lay submarine cables. You can travel. You can remain stationary. Coastal states do not get to interfere with or regulate high seas freedoms enjoyed by seafaring states in this zone, so long as the exercise of those freedoms, by the way, don't impact the state's resource-related rights. With respect to jurisdiction, a state have authorities over a vessel that fly its own flag, so coastal states don't have any role in jurisdiction once you get into the EEZ. So remember, it's territorial sea, they have rights. Contiguous zone, there's some very limited rights. Once you get to the EEZ, it's up to the flag that the vessel is flying. But with resources, as we've hinted, the power is reversed, and this is the really important part for coastal states. So in the EEZ, coastal states have complete control and rights to all natural resources, living and non-living, in the water, the seabed, and the subsoil. No other states have the right to fish, mine, or harvest in an EEZ. No one else gets to generate energy from wind or waves or currents. No one can construct artificial islands or engage in scientific research. Basically, access, seafaring states, resources, coastal states. In one sense, though, exclusive is a little bit misleading. So if you look to Article 62.2, this provides that if a state is technologically unable to fully exploit their EEZ, so maybe they don't have the capacity to fish as many fish as the actual natural resources would permit, it shall allow other countries to do so, making suitable arrangements and charging appropriate fees. So a lot of states, including the US, have, because of this, concluded reciprocal agreements to allow others to fish in their EEZ. And there are also special rules for landlocked and geographically disadvantaged countries to participate sort of in exploiting the EEZ, although this is still mostly theoretical. So landlocked or double landlocked countries like Uzbekistan and Liechtenstein don't have very much interest in developing a naval fleet for perhaps obvious reasons. Okay, next we come to the continental shelf, and this is another zone, but it's again closely related. So the concept of a continental shelf under the Law of the Sea Convention is designed to afford coastal states special rights to resources in the seabed and subsoil in situations where underwater geography creates a special link between the land and the geography underwater. The continental shelf is just about resources, and it's just about resources that are beneath the ocean floor. Access and jurisdiction, there's no special rules. It's just like the EEZ and the high seas, and the latter of which we're going to discuss next. So again, it's basically all in the hands of the seafaring states. And the continental shelf, again, for these reasons, not concerned with fish or anything else about the water. A true continental shelf is an area where the land slopes down very gently and then it goes off very steeply to an abyssal plain after some distance. Not every coast has this pronounced continental shelf. North Atlantic and the east coast of Canada and the US, you get one of these, but in the west coast of North and South America and the Pacific, for example, the Pacific Ocean gets very deep very quickly, so there's not really much of a continental shelf. So conceptually, there's kind of two categories to consider: ordinary and extended continental shelf rules. For the ordinary continental shelf, under the treaty, this just extends 200 miles from the baseline, even if the true continental shelf does not. So this gives coastal states complete control over resources, living and non-living, that are under the seabed and subsoil. The most important of which, under current technology, are really just using it for a base for offshore oil and gas platforms. But as you may kind of have noticed from that number, the treaty's provisions for the EEZ already provide the coastal state control over those resources. So this aspect doesn't really add anything. It's just kind of subsumed under the EEZ. Again, also not many parts of the world have this geography, so the continental shelf doesn't run that far in most places, and the coastal state has rights just to the ground beneath the ocean, not to the fish or navigation rights that are in the water. But there's potentially a pretty big deal at stake. Extended continental shelf rights, on the other hand, apply when there is an extra natural prolongation of this landmass. So it goes out even farther than 200 miles. And the treaty establishes very complex and detailed, exacting technical standards to assess whether those rules are applicable. Article 76 says that we have to look to factors like the slope of drop off to the ocean floor, the thickness of the sedimentary rock, the depth of the water, the distance from the shore. But in some cases, with these rules, the extended continental shelf can go out for 350 miles from the baseline, which is much farther than the EEZ, and in rare cases, actually even farther than that. In order to establish a claim to an extended continental shelf, the coastal state has to undertake really detailed and painstaking scientific research about the submarine terrain, and then it has to go and submit this research to a commission on the limits of the continental shelf. And this process can take years. So some states are currently in the process of developing and asserting these claims, especially in the far north, and they're considered that's relevant because the potential extended continental shelf of these competing countries could get into the Arctic Circle, and there's possibly quite plentiful oil resources there. So it'd be really good for them if they can make a successful claim to the authority. Article 82 requires a coastal state to pay royalties for exploiting non-living resources in the extended continental shelf. As with payments required for exploiting the deep seabed, which we'll talk about in a second, this provision has been a little bit controversial. And notably, though, the 1994 Law of the Sea Implementing Agreement abated a lot of the payments required for deep seabed mining as a result of a lot of protests, but it did not abate any of the royalties required for mining in the extended continental shelf, perhaps because it's just a lot of money at stake. Okay, and kind of in that same spirit, now we're getting really into the piratey part of this. We're coming to the last of the zones, which is the high seas. This is an area beyond national jurisdiction. This is a global commons where coastal states no longer have any control over seafaring state activities. Perhaps 60% of the world's oceans are now the high seas. Maybe a surprisingly high number for you or surprisingly low number. I don't know. And the Law of the Sea Convention opposes a couple of specific rules in Article 87.2 that limit a state's high sea freedoms, but these are really just must be sort of exercised in due regard for the interest of other states exercising their own freedom. So basically, everybody can do what they want as long as it doesn't stop anybody else from doing what they want. This is pretty easy, but access, all states have the right to navigate freely in the high seas. They can go wherever they want, they can do all sorts of activities. There's no constraint about innocent passage. You can conduct military maneuvers, you can do training, you can lay cables, do research, make artificial islands, and no state can claim sovereignty in the high seas or exclude others from using it as they wish. Sometimes, though, like an example of sort of a carve-out is a state might notify other states that they're about to do something hazardous, like conduct a weapons test or a satellite splashdown, and they'll warn others to keep away. But, the states might keep away. They might send somebody to, observe as a vessel. That's not them excluding them. That's them kind of just warning them, maybe you don't want to be here when a weapon goes off. Okay, jurisdiction. Each state, again, this is kind of intuitive, just controls vessels that fly their flag and are carried in their national registry. Ships are generally kind of prohibited from stopping other vessels of another state on the high seas. Warships have a right of approach to seek ID, but they have no right to board or to search unless there's a reason to suspect that the ship is stateless, or it's doing something like piracy or human trafficking. And foreign warships might lawfully stop and board a vessel if there's an agreement between the two states, or just if the flag state consents to boarding, but those are kind of standard principles of consent in international law. Okay, resources are the complicated part, which is the theme, obviously. And we're going to divide the discussion into 3 parts just to kind of get at it most efficiently. Those 3 parts are going to be fishing, mining, and extraction of other resources. Okay, resources. Category 1, fishing. Okay, the 1982 treaty didn't really do much to regulate fishing on the high seas specifically. Article 61 imposes a very basic obligation on the coastal states to conserve and manage fishing in their EEZ, but operationally it's just basically a blank check that lets them do whatever they want. Outside the AEZs, that was sort of generally left for exploitation, and there's some language requiring cooperation for harvesting of straddling stocks in Article 63, which is like species like cod and pollock that will go between different zones, or for highly migratory species. It's in Article 64, like tuna, swordfish, marlin, and sharks that roam even more widely. Unfortunately, as you may have guessed, since we're all old enough to have grown up during a climate crisis, this approach basically did not work. There was severe overfishing in many areas, and this depleted important schools of fish and led to the collapse of a number of vital fisheries. So fortunately, in 1995, countries agreed to a new treaty. This is the Fish Stocks Agreement, the FSA. This is separate from the 1982 treaty, but it's complementary and it's structured as an implementing agreement rather than an amendment. The FSA applies stricter, sort of consistent conservation rules for particular species inside and outside of the EEZs to pursue conservation strategy for rebuilding depleted stocks. It also sets up and sort of strengthens regional fisheries in commissions to kind of let them set quotas on the level of fish, the number of fish that can be taken, even on the high seas. The U.S. still hasn't joined the 1982 treaty, which you've rehearsed a few times, but it was an early adopter of the 95 treaty, and it's a participant in several regional fishery commissions, so this is all kind of geared towards responsible conservation. Okay, second category for resources is mining, and this is one of the most interesting, I think, and funny and controversial parts of the convention. So the original rules from the 1982 convention have been altered in important ways outside, to sort of regulate operations in the deep seabed outside the EEZ and the extended continental shelf of any country. The background of this is that for a long time, people have considered that the minerals on the ocean floor are potentially economically recoverable. And this would open, again, in theory, vast supplies of rare and very valuable minerals. Originally, Part 11 of the treaty, which accounted for almost a third of its length, declared these resources to be the common heritage of mankind, meaning they couldn't be harvested by anybody without authorization from an international agency, which is referred to very dramatically in the treaty as, just quote, the authority. To acquire such a license, corporations or states, whoever wants to go and do this deep seabed mining, would have to pay substantial fees upfront on an annual basis, and in addition to royalties paid on profits. And they also would have to share mining technology with the operational arm of this authority, which is also very enigmatically referred to as, quote, the Enterprise. Super Star Trek. I love this. They would also have to share sites that the miner had identified as being potentially profitable. So this all, again, goes towards the common heritage of mankind language for deep seabed mining specifically, given kind of just imagination about how valuable this was going to be. You also have to agree to quotas that limit production in order to protect the prices for land-based producers. Since again, especially in a lot of developing countries, rare minerals mining is a really important part of their economy. So they wanted to protect prices while allowing, sort of just exploration of the deep seabed. There were a lot of countries that were willing to accept this kind of trade-off between, the royalties and the rights and sharing facilities. The US was not on board with this at all. And this was actually the single most important issue in the US, the US had in opposing the 1982 treaty. Surprisingly, a compromise was reached in 94, which greatly moderated this common heritage of mankind aspect. The implementing agreement really transformed Part 11, but it was deliberately not structured as an amendment. And it reduced taxes that miners had to pay to the authority and really drastically scaled back the potential mining of the enterprise, so the operational arm of this international group. Nonetheless, the US was still not on board, still hasn't joined the treaties, and so what we have are just two separate regimes kind of slowly advancing forward. The first is the US, which is, kind of operating pursuant to domestic legislation, kind of doing its own thing, and the other is several multilateral consortia of different countries that operate under the auspices of the treaty and kind of institutions and procedures that are created there, and both are going forward in tandem with deep seabed mining. Okay, so that's fishing, we've covered mining, and now this last bucket is other resources. This is most recently relevant in that there's a new set of treaty negotiations for biodiversity beyond national jurisdiction. So this agreement was structured as an implementing agreement to the 1982 treaty. It was signed in September 2023, so it's very recent at time of recording. And it deals with marine genetic resources to establish an equitable system for sharing the benefits of newly discovered chemical and biological capabilities. This also facilitates state construction of marine protected areas, so it's subject only to very limited fishing and shipping activities. It also establishes a new requirement for environmental impact assessment of ocean-related activities. So all of this is really going towards just conservation and imagining kind of new cooperation systems in international law that protect biodiversity and kind of just genetic resources in general. Okay, so that's it for high seas and for various issues. Just a couple of things before we wrap up. We wanted to cover some special topics, but all this should be playing on things that we've already addressed, so hopefully no new material. Some sort of aspects in navigating, no pun intended, the law of the sea are even more complicated than you might think looking at an already very complicated map. So a classic one would be how you deal with adjacent and opposite states. So again, what happens when states are really close together or they're situated across a relatively narrow waterway and they can't claim their full EEZs? And there are a lot of places where that actually applies. You can probably think of a few off the top of your head, but Mediterranean Sea is a classic example, the Caribbean Sea, the Western Pacific. And the Law of the Sea Convention articulates, sort of principles for just dealing with these circumstances. It also establishes additional mechanisms for resolving disputes about line drawing. So Part 15 presents an array of choices for dispute resolution methods and institutions. The general rule is that the limitation of overlapping territorial sea claims is done under Article 15 by drawing a median line, each point of which is equidistant from the closest point on another state's baseline. So you can kind of imagine how that would wiggle through, the land between, or the sea rather, between the two states, and just following sort of an equitable principle between both of them. In contrast, for allocating an overlapping claim to an EEZ or continental shelf, the treaty just refers to an equitable solution in Articles 74 and 83. The really detailed task of drawing suitable and acceptable boundaries between maritime zones of adjacent or opposite states can be as difficult as drawing land boundaries. Many ICJ cases have focused on this problem. Many bilateral and multilateral treaties attempt to develop solutions. And the ICJ, for example, has kind of a list of factors that they say should be considered. So geography, history, resource proportionality, and all this kind of in the interest of equity. There's another topic that we should address, an additional set of provisions for straits and archipelagos. So the treaty establishes a specialized regime for dealing with these situations. For straits, which is when there's a kind of narrow body of water threading between two different land masses, and an archipelago, which is, a collection of different islands. So examples of straits, you have the Strait of Gibraltar, of Malacca, of Hormuz, and the treaty undertakes to kind of balance again the rights of coastal and seafaring states as best it can. So for straits, a coastal state can usually designate appropriate sea lanes and traffic separation rules, but it can't impede use of the strait. Seafaring states get a right of transit passage, which is similar to, but broader than innocent passage, hence the different name. So like innocent passage, transit passage has to be continuous and expeditious. But foreign ship and aircraft that are conducting transit passage have to refrain from threats or use of force against states that are border the strait, and they have to obey kind of standard safety rules. A good specific illustration, though, of the difference between transit versus innocent passage would be that when they're making transit passage, submarines don't have to stay on the surface. They can just operate as normal. And also foreign aircraft, and again, remember, this goes above and below. Foreign aircrafts enjoy a right of transit passage, while they don't have a right of innocent passage through a territorial sea. Okay, archipelagos. So an archipelago is defined in the treaty as a state that consists entirely of interrelated islands, which is a little bit different from a more colloquial definition. So this includes Indonesia, the Philippines, and the Bahamas, but not Denmark or Ecuador or Malaysia. Archipelagos were a new topic for the Law of the Sea Convention negotiators, and perhaps as a result, but perhaps just in general, they do treat archipelagos very generously. So the treaty allows an archipelagic state to draw baselines that connect islands way farther apart than is allowable with normal baseline rules, so up to 125 miles long, to include all of the ocean between those lines and the islands as internal waters. On the other hand, the archipelagic state doesn't get all of the usual benefits that are accorded to internal waters, and no other states have a right of innocent passage and aerial overflight, which wouldn't be provided elsewhere. Seafaring states do have a right of archipelagic sea lanes passage, so it's similar to transit passage for international straits, and that's more permissive than innocent passage through a territorial sea. And again, archipelagic state, just sort of in the interest of efficiency, can establish sea lanes and air routes through and over its waters. Finally, one important thing that we've kind of referenced at the beginning that we want to make sure to address slightly at the end here is the enforcement of these zone rules. So despite kind of the seeming clarity of provisions, or at least relative clarity by the standards of international law, many states regularly and systematically violate the rules around the law of the sea. So a really obvious example, some states claim that their territorial sea is bigger than 12 miles, which it just can't be. So some states would purport even to draw a longer baseline or farther offshore than the treaty will permit. Some states say that they're going to demand advance notification and require permission before foreign flagships enter their territorial sea, which again, they can do for the internal waters, but not under the treaty for the territorial sea. And it's kind of anybody's guess why they do this. Maybe states are just hoping that others are going to tolerate or acquiesce to this, which will create a local customary international law that just deviates from general treaty provisions. And also, sometimes these claims are asserted by very democratic states that are traditional U.S. allies and that are normally, really strong on rule of law. So it's a curious exercise when it's sort of very obvious like that. And in response to this, the Law of the Sea Convention has a number of dispute resolution options for addressing these types of disputes. So this is one of the fields where, as we kind of said at the beginning, this convention is one of the most well-developed mechanisms in international law. States also, by the way, in addition to the dispute resolution mechanisms, will just frequently use regular diplomatic channels to protest other states' excessive claims. Also, there's a third option, which is just self-help, like the U.S. Freedom of Navigation Program, for example. So, although the U.S. is not a party to the Law of the Sea Convention, it regards the zone rules as customary international law and binding on all states. So the U.S. devotes really considerable energy to monitoring and publicizing and protesting excessive claims like the ones that we just described. In addition, the U.S. Navy also sometimes undertakes deliberate and ostentatious physical actions in conspicuous violation of these excessive claims to make vivid U.S. non-acceptance and kind of stop the establishment of customary international law before it even starts. So an example would be, the Navy sending a warship through another state's territorial sea, exercising innocent passage without asking for permission, even though the coastal state has said, we're going to need permission from states. Otherwise, also, the Navy could undertake a military activity, like launching or recovering aircraft, which is permitted on the high seas in an area that some other state wrongfully declares part of its territorial sea, and says, therefore it's governed by the rules of innocent passage. So again, to kind of demarcate these geographic boundaries, the U.S. will say, we're doing what's actually allowed, and you can't stop us. The Navy undertakes maybe, not a ton, maybe a few dozen assertions like this per year. And sometimes they'll be accompanied by other like-minded states to just sort of emphasize our interpretation of the proper law of the sea rules. All right, that is it. You have made it, luckily. I'm sorry that I was going kind of quickly there in the middle and at the end and at the beginning. Hopefully you guys got everything and you can rewatch. If not, If you have any questions regarding this or other aspects of the applicable international law, please bring them to the next class. We love questions. Thank you guys for your attention. I really appreciate it. I know it's a long video, and I wish you guys all very happy sailing. Thank you.